In early 2021, January 14th, 2021, the Supreme Court of the United States issued an opinion in City of Chicago, Illinois versus Robin L. Fulton. The specific matter regarded, quote, creates an estate, end quote, that with some exceptions comprises, quote, all legal or equitable interest of the debtor in property as of the commencement of the case, end quote. It discusses matters related to bankruptcy proceeding and the possession of property and the determination of uh, obtain possession of property of the estate or a property from the estate or to exercise control over property of the estate. I've read the entire case. Elsewhere, I have provided my reflections of it at the time I read it. My first effort to provide my understanding of this case was stolen. I put it in a voice file. That voice file was stolen from my desktop and from my evidence. I consider when I read things, including opinions issued by the Supreme Court of the United States, insofar as they may pertain to my efforts at due process, and I make some sort of verbal record or even written record, that it is actually in connection with my case or with the work that I'm doing in consideration of my cases, and that it's also potentially evidentiary, especially if it's put into a format, including a vocal file, that gets stolen. This specific case, and my initial reflections on this specific case, was stolen in addition to other case reflections that have been stolen in the course of the last 2 years while I've been inside. Now, nobody else has had access to my desktop. I don't email them. I don't give anybody else access to my desktop or anything that might be on a cloud. So how it is that somebody's able to remotely access my desktop, while my computer is only here in this room, and is able to steal the files and is able to alter my records, my electronic records, including stealing evidence that I've been tracking for over 2 years while I've been inside, has yet to be explained. But I mentioned this specific case because in the initial response provided by the district court here in Dallas, one of the cases that was cited was the case MV Victor Kurnatovsky as of shipping company versus, I'm sorry, System Pipe and Supply Incorporated versus MV Victor Kurnatovsky. This case concerns a maritime vessel that was flagged as a vessel of the Ukraine. I've done some research. The initial company itself was not identified. It was a Russian company, started many, many, many years ago, but it does have a branch or districts within the Ukraine. This specific vessel was identified as Ukrainian at the time and in relationship to this case. This case is important specifically because it discusses, and this is the first sentence of the background, System, a Texas corporation with its principal place of business in Texas, filed a complaint against MV Victor Kurnatovsky in REM and against its owner, Azov Shipping Company. Now, these matters are absolutely directly, materially relevant, specific to this case, but in light of the fact that the judgments and the orders that have been issued in any of my cases have not responded to the specific charges that my cases have made or the claims my cases have made, and have misrepresented what the alleged justification for denying me my rights to due process is. And concurrently, there is now what I've been able to verify going all the way back to 2013, a direct relationship between denying me authentication of claims I've made, including in my employment, but also when it comes to access to my rights to due process, they go all the way back to 2010. Specifically, matters wherein dates, times, and events that have been mischaracterized in my life are concurrent to major events in the Ukraine. And that this specifically discusses an in rem proceeding against a Ukrainian maritime vessel that has been challenged or put in the position of the defendant by a Texas based corporation, and that this has been what defined part of the justification for denying me access to due process beginning all the way in September 2019, I contend is materially relevant and is part of my charges of securities fraud. It's very serious securities fraud. The precedents or the information that is presented in Fulton versus, or Chicago versus Fulton, I think are absolutely materially relevant in consideration of what the implications are. The concern I've had is that while I've been denied due process, my efforts at due process have been expropriated by someone else and used for all kinds of other efforts. I contend this specific case of Chicago versus Fulton is actually a case somebody else brought and was allowed to get heard before the Supreme Court of the United States and opined on in the stead of and as some sort of alternative that was accepted while my efforts were denied. And not only were my efforts denied, but my first petition that I attempted to submit to the Supreme Court of Texas in October 2017 was stolen. The actual petition itself was stolen after I confirmed with the clerk of the court of the Supreme Court of the United States they had received it and they were sending it back with a letter concerning the determination they made in regards to that case. It was stolen. And I was forced transported out of town within 6 months of that event. It's absolutely directly materially relevant. And the concern I have is, well, who would think it would be appropriate to take a woman like me and charges that are not directly connected to what was alleged in that specific case, and yet draw on aspects of my human capital, including the fact that I received technical training specifically to be an inspector of industrial materials with the intent of being a pipeline inspector, of being an inspector of the actual pipes that would be supplied in construction of a water pipeline or gas and oil pipeline. And instead, deny me due process in another legal proceeding while the actual charges of my case are not responded to, and yet the case law references, including the implications of the case law references, correlate with some kind of process that becomes even more suspect when later, upon my efforts to appeal, I'm given something that alleges it's an order of the court that talks about how my case is going to be submitted for automation as part of casework. So are you automating my case based upon case law references somebody else put in their order or their opinion that I'm attempting to appeal when the actual case itself was not addressed in what they allege was the order or the opinion? Are you attempting to establish a claim that my estate belongs to somebody else and you want to try to test me, or you want to try to torment me to see if I will relinquish control? And if that's the situation, then we have a very significant concern that goes all the way back to cases that the Supreme Court of the United States was hearing in 2008. And then this gets into issues regarding informed consent. And this gets into issues regarding abuse of power and the privileges and protections of immunity. And it gets into allegations of trafficking. However, insofar as the specific reference points here are that there are precedents that are set forth regarding exercise control over property of the estate, that when I've been subjected to an unlawful proceeding allegedly about an eviction, when I contend that what it's really about is crimes connected to acts of securities fraud and an attempt to elicit a bond on my good faith and credit in bad faith, then the concern about control over or exercising control of the property when somebody else is allowed to enter and exit, including enter and exit after refusing for over a year to provide secure doors after breaking it down themselves, becomes very concerning, including an actual safety concern and a concern I have for my actual personal safety, especially in understanding that I'm actually supposed to be out on the street right now instead of making this response. So in response to that, then please understand that in a prior effort at an appeal that was not allowed to be submitted because they refused to accept it in the appropriate jurisdiction, understand, when you say that it lacks jurisdiction, well, if you attempt to force a submission of a filing in a jurisdiction it does not qualify for, so that then you can issue an order saying it lacked jurisdiction, then when I later say that I am attempting to apply within the appropriate jurisdiction and I am obstructed until I give a kickback to the local jurisdiction that does not actually, by the letter of the law, qualify as the jurisdiction for that claim, and which, by the way, has been reaffirmed through two other procedural references in the Federal Rules of Civil Procedure and Federal Rules of Appellate Procedure, then we have a very significant concern about what is actually going on in the stead of actual access to due process. In what would have been an appeal that would have been submitted by December 14th of 2020, that was available and ready by December 4th of 2020, Rule 65.1, the Federal Rules of Civil Procedure, discusses proceedings against a surety. 65.1 states, proceedings against a surety, whenever these rules, including the supplemental rules for admiralty or maritime claims and asset forfeiture actions, require or allow a party to give security, and security is given through a bond or other undertaking with one or more sureties, each surety submits to the court's jurisdiction and irrevocably appoints the court clerk as its agent for receiving service of any papers that affect its liability on the bond or undertaking. I contend that the role of the clerk of the court, especially in an intentionally engaged effort to not apply the appropriate process at the time of accepting the case and or in connection with any misrepresentations of what the actual procedure or who the actual parties are of concern, implicates the clerk of the court herself or himself directly in potential accusations of securities fraud. And if a judge or a magistrate judge allows for their name to be put on an alleged order or an alleged judgment in connection with that case without addressing accusations of errors on behalf of the clerk of the court, then that implicates them as well in acts of securities fraud. Not only that, in this particular proceeding, we also are going to have to deal with consideration of Rule 62F. Stay in favor of a judgment debtor against state law. If a judgment is a lien on the judgment debtor's property under the law of the state where the court is located, the judgment debtor is entitled to the same stay of execution a state court would give. Now, part of the accusations is that this was supposed to be referred back to a state court when I alleged that there were federal jurisdictional claims. The denial was not at all addressing of the actual charges of the case. It attempted to remand it to nothing more than an eviction proceeding under the property code. Those were not the charges that were presented to the court in establishing a federal jurisdictional claim. Not only that, as Rule 62F points out, specific matters related to the claim of concern are referred to in Chicago versus Fulton. I am not going to give any sort of explication of my understanding or interpretation of the opinion. That is what would be appropriate for a formal response or a hearing, if not an actual cause to proceed before the court in some sort of formal written manner as part of the argument in the case. What I understand these things are is an attempt to elicit me to a performance so somebody else can use it to their credit in consideration of them providing work, i.e., they are stealing my property. This is not about exercising a judgment lien. And the context of it as an understanding of a judgment lien without establishing the legal justification for attempting to apply the lien leaves open charges that what is actually going on is an attempt at theft in connection with acts of securities fraud, which are the charges. In addition, there needs to be a consideration of what is already understood to be consideration. Hold on a second. 28 section 1739, state and territorial non-judicial records, full faith and credit. Second paragraph. If the certificate is given by the judge, it shall be further authenticated by the clerk or prothonotary of the court, who shall certify under his hand and the seal of his office that such judge is duly commissioned and qualified. Or, if given by such governor, secretary, chancellor, or keeper of the Great Seal, it shall be under the Great Seal of the state, territory, or possession in which it is made. Such records or books or copies thereof, so authenticated, shall have the same full faith and credit in every court and office within the United States and its territories and possessions as they have by law or usage in the courts or offices of the state, territory, or possession from which they are taken. Direct question is, am I being denied any actual legal, procedurally correct access to the Court of Appeals or even to the Supreme Court of the United States because local actors are intentionally engaging in acts of securities fraud. And that were their alleged records of the case to actually be submitted for review by either a peer in another jurisdiction, which is possible, for instance, in consideration of an inability to receive a fair trial in the local jurisdiction, or per an appropriate application of procedure regarding Court of Appeals and or execution, for instance, in a matter that, as was identified to me in 2017, I may well have been granted certiorari from the Supreme Court of the United States in 2017, but the evidence was stolen and has been misused by other people. What does it mean about the good faith and credit of not only the federal district court here in Dallas, but also the state of Texas, all the way down to the judgment court that allowed for that unlawful proceeding, and all the way up to the Supreme Court of Texas that refused to actually respond to numerous cases it did accept. It refused to respond to intentionally orchestrated errors by the clerk to mischaracterize a motion submitted in another case in which I had material interest. And also concurrently, a refusal to provide any authentication. It is for this reason, and with foreknowledge that these things had already occurred, that in my motion to the court, I cited both on both a list of evidence, Rule 806, attacking and supporting credibility of the declarant, as well as Rule 901, requirement of authentication or identification. This is from the Federal Rules of Evidence. I am requiring whoever the alleged clerk of the court is, whoever the alleged magistrate judge is, and whoever the alleged presiding judge is, to authenticate their identification. Are you actually a federal district judge? Are you actually a federal magistrate judge? Did you actually yourself put your good faith and credit and the good faith and credit of the court on that judgment order, or on that judgment, on that order, on those findings, conclusions, and recommendations? On every stage of the process where you refused to respond to the charges at hand and yet allowed for your name and your court to be associated with that travesty of justice going all the way back to September of 2019. Every single judge, every single magistrate judge, every single clerk of the court, including the one I talked to on the phone, who has allowed their name to be put on this case or the cases that have come before the court prior, is going to need to be subjected to, or is going to need to comply with Rule 901 of the Federal Rules of Evidence. I need you to authenticate you actually did what you said you did. And if you actually did what you said you did, then what you did is commit securities fraud in the name of the federal district court.